It's 9:04 on Wednesday, March the 11th. The House Criminal Justice Subcommittee is now in session. Members, let's take the roll. Madam Clerk, take the roll.
Mr. Chairman, you have 8 members present. You have a quorum.
Thank you, ma'am. Members' personal orders. Representative Scarborough.
Good morning. Thank you, Mr. Chairman. We have a lot of law enforcement folks here this morning from our Sheriff's Association. I'm really proud to see them out there. I know Fred and I know Chairman Doggett will want to speak to it too, but very proud that you're here, fellas. Welcome.
Here. Leader Lamberth.
Thank you, Mr. Chairman. And there are many fine sheriffs and members of law enforcement here today, but the absolute best sheriff in the great state of Tennessee is Eric Craddock from Sumter County back there. Please make Eric feel welcome.
Representative Ashley.
I just want to echo those sentiments, and I would argue with the leader that I've got the best sheriff. But anyway, I understand he's got an election this year and some opposition.
You gonna introduce him?
Well, I don't see him. He's out here.
Oh, okay.
I think he's out in the hallway. He was in my office and walked down here with me.
All right. Representative Littleton.
Thank you, Mr. Chairman. I have one up on all of y'all. I have 2 sheriffs that are here today, the Dixon County Sheriff and the Cheatham County Sheriff, and they are the 2 best sheriffs around. So let's give them a hand.
Representative Salinas.
There wouldn't be any sheriffs without moms, and Moms Demand Action is in the house. I wanted to give them a shout out.
Representative Russell, you and Chairman Farmer are the only 2 that didn't have an opportunity to speak. You want to say something?
Thank you, Mr. Chairman. I would like to welcome everybody else that's here in the room.
Well, all righty. I've got my sheriff from Lawrence County and chief deputy here with us, John Myers and George Bartiran. Good to see you. And a good friend, Lieutenant Campbell from Laverne, is here. And although he is not a constituent, he was a Giles County fella, and his family's still there. So always glad to see you. So thank you. And now for our weekly words of wisdom from our Sergeant of Arms, Mr. Tyler Muniz.
Good morning, everyone. Today's words of wisdom come to you from a man who's traveled all the way to Loompa Willy Wonka. If you want to view paradise, simply look around and view it. Anything you want to do, do it. Want to change the world? There's nothing to it. Y'all have a great day.
All righty, we'll go through some housekeeping issues right off the bat here. Item number 2, House Bill 689 by Leader Camper is off notice. Item number 4, House Bill 1082 by Leader Camper, off notice. Item number 28, House Bill 1459 by Chairman Clemens, off notice. Item 30, House Bill 2622 by Representative Miller, off notice. Item 51, House Bill 1475 by Representative Bulso, off notice. Item 52, House Bill 2618 by Representative Gant, off notice. And item 55, House Bill 2400 by Representative Sparks, off notice. Item number 1, House Bill 2504 will be rolled to the hill. Brings us up to item number 3, House Bill 1081 by Leader Camper. There's a motion and a second. There's an amendment code. Amendment code 14543. You wish to proceed with that amendment?
Thank you, Mr. Chair. Yes. It puts it with the codes that was changed from last year with when Halsey redid the codes. It needs a motion and a second.
All right, you recognized on the amendment. What does the amendment do?
Thank you, Mr. Chairman Committee. Mr. Chairman Committee, years ago, Representative Faison and I took the challenge to pass a bill that allowed people to get their records expunged. And it was a lot of work. We worked all summer and we did it. So since that time, a lot of people have had an opportunity to get their records expunged, move on in life, get those promotions that they weren't able to get before. What this does is it changes the waiting period. I think when the bill passed, it put like 5 years in, and there's been some amendments over the years, 5 and 10 years based on the offenses. What this would do was establish the following waiting periods in which a person could petition to get their records expunged. 3 years for misdemeanors and Class C felonies, 6-year waiting period for Class D, and a 10-year waiting period for Class C and above felonies. It's a tiered system so that everybody is not all clumped into one. And if you had a lesser offense, you don't have to wait as long as someone who had a more serious offense. And that's really all it does. It sets up a tiered framework for a person to be eligible to have their records expunged. The petition process is the same. The amendment put the codes, reflect the codes from when last year when Halsey redid the entire code. And so it just aligns it with that and to make it effective this year, July 2026. Thank you, Mr. Chairman and committee. That's what the bill does.
All right, thank you. We're on the amendment. Questions on the amendment? Any objection to the question on the amendment? Seeing none, we're voting to adopt Amendment Code 14543 on the House Bill 1081. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt or own your bill as amended, and you basically have.
Thank you, Mr. Chairman. I did. I just didn't realize, we were on the amendment at the time. So that's what it does. The amendment rewrote the bill, and that's what it does.
All right,
So I
thank you.
appreciate
First on my
consideration.
list is Leader Lambert.
Madam Leader, you know I have the deepest level of respect for you.
You do.
And have supported many bills that have expanded our laws in Tennessee to allow for folks that have not committed new crimes,
Right.
that have had one or sometimes even two instances where they broke the law to be able to get an expungement. But this is just a bridge too far for me. It's not a waiting period of 5 years or 10 years. It's 5 years or 10 years when our law enforcement officers that are here today have not had to expend their resources and arrest these folks again. It's 5 or 10 years when these folks have not committed new crimes. It's 5 or 10 years where they've not committed any new crimes against other Tennesseans. To me, 5 years to prove that you're worthy of having an expungement, which is based upon our Christian belief of forgiveness, it is wiped away as if it never occurred. So, I mean, an expungement is a big deal. And I support it. But that 5 years and that 10-year period, especially for some of these are C and D felonies,
Mhm.
to me, that's a reasonable ask of someone to prove to all of us as Tennesseans that they're not going to commit a new crime. So with all due respect, if I don't get pulled out of the committee to run over to Commerce, you might text somebody over there or something, drag me out of here. I'm not sure.
Oh,
But
no, I got to move there. I'm on that committee. I got to get over there.
exactly. So if I don't have to step out, I mean,
Yeah,
I'm a
I
no on
understand.
this, but at the same time, I understand where your heart is on this. And the expungement laws we have are very valuable. I just think people ought to prove that they're not going to commit new crimes before they can get some expunged.
I appreciate
Yes, ma'am.
Thank you, Mr. Chairman. I appreciate your candor, and we've had these conversations before. I know your heart. So what I want us to understand, however, is this person has already served their time. They've come back. They're trying to move forward in life. And so what I'm saying is some are more severe than others, and I get that, and they should wait 10 years. And I get that they should wait 5. But some of the offenses are minor offenses. They are misdemeanor offenses, and it gives a person hope that if I keep my nose clean, if I do all the right things, I've repaid restitution, I've done everything right, they're just asking for an opportunity to be eligible. It doesn't have to be granted. It's just an eligibility thing that they still have to petition the court. They still have to prove that they have changed their character and they've done all of these things. So I'm just asking for a tiered approach, but I really appreciate your comments, Mr. Leader.
All right, thank you, Representative Salinas.
Thank you, Chairman. So I like the tiered approach because this is in addition to the time that they have served, right? So they may have been, it's 5 years depending on, or 10 years depending on the offense, but this is in addition to the time that they were in jail, right?
Yes.
Okay. So potentially it could be someone that hasn't been in trouble. Let's say their sentence was 10 years plus the 5 years, that's 15 years, correct?
Yes.
Am I interpreting that correct? Okay.
Correct.
I had 2 women visit my office yesterday, and they weren't from Shelby County. They were from other parts of the state, and I don't remember exactly where they were from. One of them was the chair of the Chamber of Commerce, the Women's Chamber of Commerce, and I had talked to her, and then she told me, she's like, hey, I'm a felon, and the reason, she's like, I want to tell you why I have a business. And she goes, the reason I have a business is because I would get through all the applications, the background check would come, and then I wouldn't get hired. So I had to start my own business because I didn't have an option. So we're asking people to pretty much not have a job for 5 years and also not get in trouble, because that's what these people are facing. Is I am having a hard time getting a job because of the thing. And then a lot of the time, from what she was telling me, is that people aren't left with options and therefore they go back to committing crimes. So I really like your bill. I like that it's a tiered approach. I like that it doesn't have to be granted.
That's true.
Potentially, they can choose not to grant these expungements.
That's true.
Thank you for bringing this bill.
Thank you. I appreciate your Thank you. I appreciate your comments.
All right. Representative Farmer, Chairman Farmer.
Thank you, Mr. Chairman. And I just wanted to add on to what Leader Lambert had said. What everyone don't know is that most, if not all, of these folks that are asking for these expungements have been in trouble before, because you have an opportunity to use what's called a judicial deferral or some sort of informal mechanism. And we all have that. So if you ever get in trouble, you have the opportunity to use your deferred plea on most of everything other than some A and B felonies and DUI. And there's some carve outs there. But what we got to remember is these folks, for the most part, they've been in trouble before. So it's not like this person's just coming in here with a first time offense. So I just wanted to add to that, let everybody know that there's more to this than, you know, what we talked about already. But I did want everybody to know that these are typically not first time offenders. So thank you, Mr. Chair.
Thank you. Anyone else on the list, or you want to respond?
Thank
Go
you.
ahead.
So to my recollection, well, the group that I'm targeting, this is their first time, a lot of them. And they have made a mistake in life. And they have paid their debt to society and come back and trying to reintegrate into society. And this one second chance is the opportunity I'm talking about. So I don't think these are people that have constantly reoffended, because they're not even eligible. It's only a one time. If you only get one bite at the apple. And I'm saying in that one bite, a tiered approach might be appropriate. That's what I'm trying to accomplish. But I appreciate your comments, Mr. Chairman.
And to just follow up, you are entitled to an expungement if you use your deferred plea. So that's going to happen on those first time offenders. And typically, I'm trying to think if there's a crime here other than a DUI. I'm trying to think of an A, B, or D, an A misdemeanor, an E or a D felony, or even I'm getting up into the C's that wouldn't be eligible for a judicial deferral. So those folks will get their expungement after their probationary period is over by operation of law. Well, they'll have to apply for it, but they're entitled to an expungement. So this would be a second expungement right here is what we're talking about, potentially.
Thank you, Mr. So are you talking about like judicial deferment, a different program available through judicial deferment? Is that what we're talking about? I don't understand the language you're using. I'm just trying to be clear in my mind what it is you're talking about.
Well, and we could have this conversation later. I don't want to go down the rabbit hole, but some people call it a deferred plea, judicial deferral, but there is by statute a mechanism that a person that has not been in trouble before, you get a clearance from the Tennessee Bureau of Investigation, a court will allow you to use that deferred plea. So there is a mechanism in the law for folks that haven't been in trouble before to go through whatever they need to do, and then probationary period, whatnot. After that's over,
their charge can be expunged like it never happened before, just like you're doing here. So that's what I'm saying. I'm not trying to get the committee off track. Thank you, Mr. Chair.
Thank you, Mr. Chairman. I understand completely what you're saying. Should this bill come out of here, or would you be open to helping me amend it to, if they have been in a deferred program, that they would not be eligible for this? Is that something maybe you'd be open to? Help me kind of come up with an amendment that does that. If not, I get it, but I'm just trying to give people a chance to move on in life. And if they have offended and they don't deserve the second bite, I'm with it. But if they haven't, I think they need a chance. People are still dealing with things that they've done 20 years ago in their life. And they are a completely new person. And I'm just trying to help that group. But I get your point.
Yeah. Hey, we're here to help. You know,
Thank you.
anybody whose heart's in the right
Yeah.
place, and they're 20 years removed. I totally agree with
Yeah.
you. You know, I mean, something happened 20, 25 years ago. I mean, yeah, we need to look at that.
I got it.
So,
I thank you.
yeah.
Thank you, Mr.
You're
Chairman. Thank you, Chairman Dodd.
Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 1081 as amended to full judiciary.
Ouch.
Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 2 ayes and 7 noes.
House Bill 1081 as amended fails.
Thank you, Mr. Chairman. Thank you, committee. Appreciate the dialogue.
Item number 5, House Bill 1679 by the Chair Lady Moody. You're recognized. There's Amendment Code 13147. You wish to proceed with that amendment?
Yes, thank you.
You're recognized on the amendment.
Thank you, Mr. Chairman and committee. I am here today. You know, we get lots of proposals for bills. I love it when someone back home has a great idea. And that someone is here with us. If you have more questions, Scotty DeLashment here. He's our court administration and back there in Tipton County. But so they are seeing a gap in the law regarding youth accountability with vape issues, and especially in West Tennessee is where we're seeing this. So this, we hope the outcome of this bill, if it is passed, would correct the youth vaping by redirecting the penalties away from parents and onto the youth via the judicial courts with community service in conjunction with rehabilitative accountability. So there's a lot of details in there with that. And I know we're anxious to get our calendars out, but that is the gist of this bill. And I think is new and refreshing. And hopefully it will really help the youth with the extra services they will get to deal with this issue. But if you have any questions for me, or if you'd like to hear from my guest that is here, just let me know.
Thank you. I've got two that want to ask a question, but do you want to hear from the guest first? Okay. Without objection, we'll go out of session. Hear from Scotty. If you will, come forward. You can use the microphone there. Introduce yourself for the record. You'll have 3 minutes for comments. We'll open it up for questions.
Thank you, committee. Thank you, Representative Moody, for having me. My name is Scotty DeLashman. I'm the court administrator in Tipton County for the general session and juvenile courts, but some of y'all probably remember I also wear another hat. I'm the president of the Tennessee Fraternal Order Police, and that's normally why I'm here. So it's refreshing to be here for something different. But Tennessee says we're restorative justice. That is what our juvenile court model is based upon, but yet we're doing a civil penalty for a vape. And it's taking food off the table for some of these kids, because if you're low income, your parents don't have the money. And unless the kids have some skin in the game, they could care less if their parents have to pay money because it's not coming out of their pocket. An informal adjustment, as you know, doesn't stay on their record it stays on for 3 months. And we also had it so that you cannot be on supervision by DCS. This is definitely going to be supervised by the county probation officer because it would create a tremendous fiscal note for DCS, and we don't want to overburden the government. It still allows a civil penalty because the bill that I wrote says may instead of must. So it reduces the civil penalty from $50 down to 10, up to 50, or you can waive it. It puts more tools in the judge's tool belt. It doesn't require anything. It just gives them some more accountability, because if we are restorative justice and we are rehabilitative justice, if the kid has zero responsibility, why should they change? They have no responsibility, no accountability. They could care less, as I said, about the parents paying their fines. And I believe it's just the right thing to do. I just apologize that this went into law in 2021 and it took us until 2026 to decide we needed this, because I'm a member of the West Tennessee, part of the Tennessee Children for Community, or excuse me, Tennessee Children for Youth, and we meet as YSOs at least 4 times a year, and all of us in West Tennessee absolutely hate the civil penalty, and I humbly ask y'all pass this, and I appreciate you taking my testimony today.
Thank you for that. Are there any questions, Representative Salinas?
I understand the bill, but can you describe what's currently happening right now for is it 21 and under? Just because I'm not as familiar with the process as it currently is.
The part of the process I want to change specifically is the 17 and under. And right now it is a $50 fine that's assessed to the parent. So if you are in a low income area and your child gets caught with a vape, we're in the community or in school, you get a summons to court. All the court can do is issue a civil penalty to the parent. Well, if you're low income, $50 off your budget is a lot of money, and the child has no responsibility, and it's punishing the parent. And most of these vapes, the parents don't buy for the kids.
And so what court does this usually go through right now?
It would go through the juvenile court.
Juvenile court, that's what's going right now?
Yes, ma'am.
And then the bill would still keep it in juvenile court?
Absolutely.
Okay. Those are all my questions.
Representative Powell.
Thank you. I appreciate you being here and giving your testimony. The one thing I'll disagree on is, I tell you, I can assure you, if my mom was assessed a fine, then it was coming out of her pocket, but it was coming out of my hide. So I just want to say that, and I know a lot of parents are the same way.
Well,
but I do have a couple questions. So you're suggesting instead of the fine, then the juvenile would do like community service. Is that correct?
correct.
Okay. And how many hours of community service for that?
That is up to the court, but it has to be a max of 50, which it's a tiered approach, is the way most courts work that. But to go back to your parent, that was several years ago. If you whip your kid now, they call DCS on you.
Well, not always. I get a little nice spanking every now and then, but I was a pretty good kid. But I'll say this. So I guess the maximum is 50 hours. I think the one thing we're missing here, though, is I know if the kid did not have a driver's license, then this actually could put an even bigger burden on the parent for having to take them to and from community service or to work that. And I think a lot of times we assume that it's easy to do those hours when in fact it's not. So, you know, if it was, I have 2 kids as well, but let's say so this was to happen at their point, I'd almost rather pay the fine than to have to take my daughter's 15, she can't drive, to and from community service. So that's I see where you're intended here, but I think that is my concern with this. And I guess my other question is there any other, can you use another example of, besides vaping, where this might apply or it's being applied already?
This is, well, any unruly act or any delinquent act in the state of Tennessee can get community service except for vaping and tobacco products. It was carved out in 2021 to take it out of the unruly and has a special law that covers just it. Basically, I'm saying put it back with the other laws that cover unruly behavior.
Okay. And one final thing, is there any increased, I know, but like, what is the penalty if the place that sold the vape, I think that's where the biggest responsibility lies. What are their penalties and what do you guys do to them?
Well, the juvenile court wouldn't do anything to them. The sheriff's office or law enforcement still can write them a citation. This doesn't affect that at all, because I would personally like to see more tobacco shops get citations if they sell to minors, because I know we have used our sheriff's office in the past to do stings where they take underage youth and go in, and if they buy, they get a citation.
Okay, thank you.
Representative Salinas.
Thank you. I really appreciate it because something you said just kind of, so right now there are no penalties for anyone that sells vapes or let's say cigarettes or tobacco to, because you said you were focusing on 17 and under. There's nothing
No, ma'am. There are laws, but it's not this law.
out of this. Okay.
This law wouldn't affect the laws that are already on the books for the tobacco shops, the gas stations, and just an everyday citizen that buys a pack of cigarettes for a kid and hands it to them. Those laws are not affected by this bill. That's
Okay.
why I didn't go into that.
Got it. Thank you for the clarification. And so what are the penalties for someone that, for a shop that sells?
A shopkeeper would get fined for the first time, and it's a tiered approach like everything else, and it eventually gets up to where you can lose your license, but that's mainly governed by the Department of Agriculture.
Okay, thank you.
Leader Lambert.
Well, since we went there, let's not ignore the fact that providing vapes, cigarettes, alcohol to a minor is an A misdemeanor and carries up to 11 months and 29 days in jail. And those folks can be criminally charged with that offense, right?
Correct.
Just want to make sure everybody understood. It's not just a civil fine. It's not just a fine for the shopkeeper or whatever. If you provide those type of prohibited substances, you can and many times do go to jail. So just want to make sure that was said.
Absolutely, and I thank you for bringing that up. I just didn't want to cloud the waters since I'm just focusing on the juvenile part.
Any other questions for our guest? Seeing none, thank you for being with us today.
Thank you for your time.
Yes, sir. We're going back in session. Any questions for the sponsor? We are still on the amendment, by the way. So any objection to the question on the amendment? Seeing none, we're voting to adopt Amendment Code 13147 on the House Bill 1679. All those in favor say aye. Aye. Those opposed, the ayes prevail. You adopt your own your bill as amended. It's been explained. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none, we're voting to send House Bill 1679 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 2 noes.
The ayes prevail. House Bill 1679 as amended goes on to full judiciary.
Thank you, Mr. Chairman and committee.
Chairman Farmer.
Yeah, Mr. Chair, I was going to ask before we take up item 6, if we could move to item 7. I saw Jefferson Garrett back there. I thought we could knock that one out.
Yes, sir. Thank you. I'm gonna skip down and take up just a couple bills here before we get to item 6. So without objection, we're going to roll down to item number 7, House Bill 2452. Representative Garrett, you're recognized. No amendments.
Thank you, Mr. Chairman. Mr. Chairman, this legislation involves expungement. And what it does is it updates the Tennessee law governing expungement for individuals who have received a pardon, ensuring the pardon process provides meaningful relief while maintaining strong public safety exclusions. The key provisions of this particular piece of legislation that removes the overbroad language, nonviolent crime and requirement, and replaces it with clear felony exclusion list that cannot be expunged. It reconciles the law to provide what many people think already happens after a pardon. And believe it or not, I was unaware that if you receive a pardon that you not are actually restored with all of your rights. This piece of legislation will do that. So with that, Mr. Chairman, I'll be happy to take any questions from the committee.
Questions for the sponsor? Representative Salinas.
So let's say an elected official got a pardon, and if your bill were to pass, would they be able to run for office?
Thank you, Mr. Chairman. I don't think that would affect this at all. If they meet the requirements of the statute, it wouldn't matter if they're an elected official or not.
Okay, so are elected officials that received pardons, because that's the most ones that I've seen of receiving pardons. I know there's a lot of people that receive pardons, but those are the ones that I'm the most familiar with. So right now, under current law, is someone that has been pardoned allowed to run for office without your bill? I'm just trying to understand.
Thank you, Mr. Chairman. This is a pardon from the governor. So I don't believe whether or not they receive a pardon affects their ability to run and qualify for office.
Thank you for the clarification. So this doesn't involve like a presidential pardon. This is just for the governor's pardon.
Thank you, Mr. Chairman. No, this is a pardon by our governor of the state of Tennessee. It does not include anything to do with a presidential pardon.
Okay, thank you.
And this is setting up a process that an individual can go through, that it still involves going before a judge.
Absolutely, it does. It's still the same process. All it's doing is just clarifying the nonviolent term and actually expressly listing the crimes, the violent crimes that are excluded from expungement.
Okay, thank you. Leader Lambert.
Thank you. And on that point, again, this doesn't change anything about who can or cannot run for any kind of public office, doesn't change anything about really who can and cannot get an expungement, except for the fact we constantly change the definition and the offenses that fall under nonviolent or violent for a variety of reasons, how they're classified in prisons, whether or not they're eligible for parole or probation, how their case is treated many times, even when it's going through the court. But we haven't updated this statute in quite some time, and it uses those terms as if it was back when this statute was first written decades ago. What you're doing is saying, hey, this list of violent crimes, you absolutely cannot get expunged, but everything else, you can at least go in front of a judge if you've gotten a pardon and plead your case to that judge, so the judge can make a determination whether or not, the governor pardoned you, whether or not you still deserve an expungement. Is that accurate?
That's accurate. It's not automatic by just virtue of the pardon. You still have to make sure it's approved by the judge of the convicting tribunal. I mean, you have to go through the same process now. This is just clarifying what violent crimes are excluded or available for expungement. Just like
I'll just bring up an individual who just yesterday, had kind of a big night and who has helped out our community specifically. Jelly Roll just got a pardon from our governor, and I don't know if this could help him or not. It might, but there's a bunch of people out there like that who had crimes a long time ago that got a pardon at some point and have changed their lives, have contributed back to society, just as we were talking about a bill a while ago. And if the governor has gone to an extraordinary length of pardoning folks, and I don't know if anybody else saw the video between the governor and Jelly, but look, if it doesn't bring tears to your eyes and warm your heart, I don't know what will. That's a guy who's changed his life. Doesn't mean he's perfect. I don't think he hides that. But he has a criminal history. And if there's an opportunity for a guy like that to maybe be able to get his record cleaned up, I think it's worth at least giving him a shot in front of the judge. Just my opinion. Thank you for bringing the bill.
I appreciate that. He should be redeemed, and I think that's a good example.
Thank you. Any other questions for the sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2452 to full judiciary. Has everyone voted? Does anyone wish to change their vote? Let's try it again. We were on the wrong bill on our little doohickey that we use here. So let's try again. We're voting on how it's still showing the bill by Todd here. Well, mine says Todd on my. Well. All right, members, we are going to do a roll call vote. So when your name is called, you will answer yes or no. Madam Clerk, take the vote.
Representatives Ashley? Yes. Ashley votes aye. Farmer? Farmer votes aye. Lamberth? Aye. Lamberth votes aye. Littleton? Aye. Littleton votes aye. Powell?
Aye.
Powell votes aye. Russell? Aye. Russell votes aye. Salinas?
Present, not voting.
Salinas votes present, not voting. Scarborough? Aye. Scarborough votes aye. Chairman Doggett?
Aye.
Chairman Doggett votes aye. Mr. Chairman, you have 8 ayes and 1 present not voting.
The ayes prevail. House Bill 2452 moves on to full judiciary.
Thank you, Mr. Chairman, committee.
Thank you, members. I'm going out of order, but I've got my sheriff that just walked in, Sheriff Joe Purvis over here wearing a suit. It's good to see you. Thank you for being with us. All right, let's jump to item number 8, House Bill 2260 by Representative Martin. You have a motion and a second. There's no amendments. You're recognized.
Yes, sir. Thank you, Chairman and Committee. Currently, the penalty for arson is a Class C felony unless the target was a place of worship, which enhances the penalty. This bill would also enhance the penalty of arson when the target is a pregnancy resource center. The penalty would raise from a Class C to a Class B and felony. You may recall an attempt arson attack on the Hope Clinic for Women in Nashville a few years back. This was not an isolated event, and pro-life nonprofit organizations have cataloged dozens of instances of graffiti, intimidation, property damage, and arson. This bill prioritizes the safety of these facilities, their staff, and the pregnant women that come there seeking help. And thank you, Committee and Chairman. I'll stand ready for any question.
All right, thank you for that explanation. We are going to pump the brakes for just a second. We're going to log out up here and we're going to log back in. So if everybody would do that. We're good? Everybody back in? Okay. We'll see what happens. Anyone have questions for the sponsor? Representative Powell.
Do you know, are there similar penalties for other facilities such as this? Or not such as this, but just in general, facilities with help that might assist with reproductive health care?
What I'm familiar with is that what we did for churches and mosques and temples and someone that would arson those, we upped the penalties on those. And this is bringing those resource centers into that same level.
Okay, so just those resource centers, but not other centers that might provide reproductive health care?
No, sir. What I've done is taken the definition that we use for these facilities that help women that are seeking help during their pregnancy.
Okay. And I've got no problem with that. I guess my challenge here is we're setting a different tier. And I think we should protect all centers that provide reproductive health care. So for that reason, I don't know, but I appreciate what you're doing here, but I think we should do everybody on the same level. Thank you.
Sure. And the definition for a pregnancy resource center means a nonprofit organization that provides care and resources to assist women and families facing difficult or unexpected pregnancies, including providing counseling, financial assistance, food, clothing, medical assistance to pregnant women, and reimbursing social service providers who prepare adoptions throughout the state for services and programs targeting at-risk women and families with immediate ongoing needs related to unexpected pregnancy. That's how it's defined.
Representative Salinas.
So under your bill, a pregnancy resource center would have to be a registered nonprofit organization, correct?
The bill says that it means a nonprofit organization that provides care and resources.
Okay, so if I had a resource center that wasn't a 501c3 or any other tax designated nonprofit, it wouldn't apply to them?
Not according to the language in the bill that we have here. This is about nonprofit resource centers that are helping women that are in crisis.
Okay, thank you. I agree with Representative Powell. I don't think that we should isolate centers that are providing reproductive healthcare to their clients, it should be protected by all of the people that are doing that type of work. Because in my county, the police had to come to one of our our reproductive healthcare clinics because people were trying to block the door, and we had to take resources. Like Memphis police had to come, and you all love to talk about how Memphis is such a crime-ridden city, or all the talking points that y'all guys used. But we had to divert a lot of our resources from MPD to come to this clinic because of the threats that they were facing. And under your bill, that clinic wouldn't be protected.
Well, first of all, I've never mentioned Memphis as a crime-ridden city until you mentioned it. And second of all, this isn't about someone blocking a door. This is about trying to set a place on fire, trying to burn it to the ground, which is something that was attempted at the Hope Clinic for Women here. And it's happened. I have 96 registered cases where this has happened at the Compass Pregnancy Center in Buffalo, a $500,000 expense in North Carolina. A Motel cocktail was thrown through, and a Lincoln Crisis Pregnancy Center. And even here in Tennessee at the Hope Clinic for Women, there was an attempt to do that. So this is about arson. This isn't about blocking a door. This is about trying to destroy the opportunity for women in crisis to find the help and safety that they would find, not unlike they would find in a house of worship, a temple, a mosque, a church, where they could find the peace that they need in the time of distress that they find themselves.
Last brief question, please.
Yeah, I appreciate that you haven't referred to Memphis. I was more talking in general terms, not specifically to you, but I appreciate that. And thank you for clarifying the arson part of it, because the Planned Parenthood clinic in Knoxville was a victim of arson as well.
Thank you. Leader Lamberth.
Move previous question.
Previous question called. Any objection? Seeing none, we're now voting to send House Bill 2260 on the full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 2 noes.
The ayes prevail. House Bill 2260 moves on to full judiciary. Item number 9, House Bill 2264. Representative Martin. You recognize there's Amendment Code 14225. You're recognized on the amendment.
Thank you. Thank you, Chairman and Committee. House Bill 2264 is amended, establishes a Class A misdemeanor for those who disrupt the worship of a religious assembly. Most of us followed the events which took place earlier this year in Minnesota, and regardless of one's political opinions or personal feelings, the right to worship is a fundamental pillar of the American way of life. This federal administration stepped in to prosecute those who disrupted the services at City's Church. However, the Department of Justice may not always prioritize religious freedom in this way, and this bill expresses the intent of the state of Tennessee to always uphold the right to worship. And with that, Mr. Chairman of the Committee, I would appreciate a favorable vote.
Thank you. We are on the amendment right now. This bill has been before us before. Are there any questions on the amendment?
And I don't know if I direct this to the sponsor or to the chair, but was this I thought we moved this bill. It was voted out of committee. Is this the same bill? Did he present it? I'm confused. Sorry.
No, sir. There were 2 bills that dealt along a similar avenue that dealt with, one was involved trespassing, whereas this one is specific to disruptions.
Okay. And there's no conflict between the bills?
I believe the amendment was intended to address what potential conflicts could be there, but Representative Martin, you can speak to it.
Yes. In the amendment in Section 1, letter D, if conduct is a violation of this section is also a violation of 39-14-406, then the offense may be prosecuted under either but not both statutes as provided in 3911-109. The other bill that I believe you're referring to that Chairman Todd brought was about trespassing. This is about interrupting the worship service in a church, a mosque, a temple, a religious assembly. That's the difference. One's trespassing. This is about interrupting the services.
Has this been a problem in Tennessee that you can reference?
Absolutely. At the Olivet Baptist Church in Chattanooga, Tennessee, on December the 26th of 2021, there was a young man that cold cocked a fellow on the front row. of a church. My barber who cut my hair on Monday was telling me that he'll never forget 40 years ago, and he was sitting with his family at the Eastridge Baptist Church, that a group who had left the church, they showed up on Sunday morning, walked down both aisles, raising Cain about things like that. And I remember just in 2024 that I was sitting in Christ Episcopal Church in Savannah, Georgia, when Antifa showed up in the middle of the service when a man was speaking there and started throwing banners down. And about the time they got rid of those people, some other folks stood up and were raising all kinds of Cain. That is, in America, people have the right to their religion and it to be unmolested. And I love what President Washington said. He said to the Jews in Rhode Island, he said, you know, it's not that there's no sanctuary for bigotry in our country or no persecution. And he went on to say this, it is now no more that toleration is spoken of like it's our job to tolerate you, but everyone has a right to sit under their own fig tree and their own vine. And that is what America is about. And that's why you can't let the self-righteous people come in and destroy someone else's peace and someone else's religion.
Yes, sir.
No, I appreciate you answering that question. I agree with a lot of what you said. I find these are troubling times right now. My congressman is basically attacking Muslims in my community, and I found that outrageous. These are all people of all faiths have served our country. They fought for our freedoms. They protected everything we believe in. And so, I agree with a lot of what you said. So I just wanted to say that. Thank you.
And I look forward to your favorable vote. Thank you.
Representative Salinas on the amendment.
I can wait till the bill.
Okay. Any other questions on the amendment? Seeing none, any objection to the question? All those in favor of adopting Amendment Code 14225 on the House Bill 2264, say aye. Those opposed? The ayes prevail. You adopt or own the bill as amended. Representative Salinas.
Thank you, Representative Martin. I'm Catholic, and I really do appreciate aspects of your bill. That's why I'm running a safe spaces bill for churches as well, to keep them safe from ICE. Because I do agree with you that areas where we pray should be safe for everybody. And there have been churches in my community that have been targeted. So I appreciate that. My question is, and I hope I can count on your support for that bill. How does this apply to like religious schools, for example, where you have students so you have places of worship, right? I went to a Catholic school where you have like a chapel, or they're using the classroom to do prayers. I have a Muslim school in my district that does prayer 5 times a day. How does your bill interact with those spaces?
This bill doesn't mention schools. It mentions religious assemblies. And so we're talking about when folks are gathering for religious assemblies, not for an educational purpose. That's what this bill is in reference to.
So at my school, we used to have weekly mass. So would your bill protect, like, let's say someone's trying to disrupt our weekly mass, or one of the morning or evening prayers right now, I know it's Ramadan, that's an assembly. And we did have like a chapel and sometimes we had mass in the gym when we had really big mass, when like the whole school was invited. If someone was trying to disrupt that, how would your bill deal with that?
Well, this bill deals with religious assemblies. So if you're having an assembly during a school time, I think that would be something that perhaps the assembly part would be a part of that. But this is not about schools. It's not about parochial schools, Muslim schools, Christian schools. This is about religious assemblies where people have gathered of faith for worship.
I understand. I just want to be clear on that, because one of the schools in my district has been targeted while the kids were in school. And I just want to, and sometimes they are in prayer, sometimes they're not. So I just want to understand that part. Thank you.
Any other questions for the sponsor? Representative Powell, briefly.
I just have one more, and you're actually moving me there a little bit. Can you explain? So, who was the one who makes that determination? I guess would it be any member of that church could do that? Would it need to be the pastor under this? Like, because the other thing I don't want to see is like if somebody, I don't know if this could be weaponized in some way. I'm just, if you could answer that, that would be helpful. Just kind of give an example. I know you gave some examples, but
Sure.
just kind of how would that work?
Yes, sir.
Well, yeah, the bill says this, is that when the activities of a religious institution by making utterances and gestures displays in a manner that is offensive to the sensibilities of an ordinary person. So that would be something that I think a judge would deal with as far as that. As far as how would that be addressed, I think it would be the leadership of a temple, a mosque, a church, whatever the religious assembly would be, that, I mean, when these things have happened and I've observed them and I've read about them, the leaders of these congregations, whatever they are, if they're Jewish or Christian or Muslim, whatever, they're the ones who have approached and said, we're not doing that here.
Okay.
And so, if this is going to be prosecuted, that would be the standard is what's in the bill here.
So just one more quick question there, because I've attended a lot of churches, a lot of different faiths, and different religious assemblies from different faiths as well. And I'm Episcopalian. I know you referenced that in your comments. The church, I think in Georgia, you said it was Episcopal church. There are some churches where I've attended, in some faiths, people stand up and, will run around the aisles and up and down. They're moved by the Spirit, right? If something like that happened and somebody went to an Episcopal church and was moved and started running around, that wouldn't apply. I mean, is that we're talking about a true disruption? I just want to be very clear here because it's we need to. I think the language leaves a little bit up to interpretation. So if you could just talk about your intent of what you mean there, that'd help me get there. Thank you.
Yes, sir.
I don't know if you remember that old song about the Mississippi squirrel that got loose in Pascagoula. And, sometimes people will be in a worship service of some sort and perhaps have a different tradition, but they're going to be respectful of the place that they're in. That's something that local church, no one's going to prosecute anyone for being filled with the Holy Ghost and praising the Lord. This is about, as the bill says here, it's about the ordinary offense is to the sensibilities of an ordinary person. And so that has a lot to do with the intent of what that would be.
Okay.
Any other questions for our sponsor? Seeing none, any objection to the question? Seeing none, we're voting to send House Bill 2264 as amended to full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 1 present not voting.
The ayes prevail. House Bill 2264 as amended moves on to full judiciary.
Committee.
Let's go back to item number 6.
Motion.
Item number 6, House Bill 2064 by Chairman Todd. You have a motion, a second. There are 2 amendments. Which amendment or?
Thank you, Mr. Chairman. I would like drafting code 15412.
Amendment code 15412. You are recognized on the amendment.
Thank you, Mr. Chairman. The bill as amended.
Does this amendment make the bill?
It does make the bill.
Okay. Well, any objection to the question on the amendment, we can put it on the bill and then open for discussion. Any objection? Seeing none, we're voting to adopt amendment code 15412 on the House Bill 2064. All those in favor say aye. Those opposed, the ayes prevail. You adopt. You're on your bill as amended. You're recognized.
Thank you, Mr. Chairman. This has been a long process of a few years' work, and I first want to commend our legal staff. Ms. Sonia and Ms. Fogarty have been absolutely wonderful to work with over this period of time, getting me amendments finally timely filed and giving me advice. And so I've been very grateful to them. Just wanted to mention that on the record. In 1989, the legislature took some actions to redo a lot of laws on the books that dealt with firearms, and they infringed on the Second Amendment considerably. And ever since then, we've had court cases that have tried to address this. We've had bills filed. And so I wanted to set out to try to flip the language that is in our current code. It starts out in 3917-1307 saying it is a crime to carry a firearm or a club, period. Then you have all kinds of defenses and exceptions built into that, and that is antithetical to the Second Amendment, the United States Constitution and our civil rights. So in light of the recent decision in Hughes versus Lee, the court indicated our current laws prohibiting the carrying of firearms are unconstitutional. It also stated the prohibition of carrying in parks was unconstitutionally too broad. This bill aims to flip the language in 3917-1307, where it creates a crime of carrying so that it is more in line with the wording of the U.S. Constitution and as it applies to the state's obligation to protect civil rights. To accomplish that, this bill removes those unconstitutional provisions, yet reestablishes prohibitions and defenses currently in law, such as those regarding felons and juveniles. For clarity, I'm glad to walk through every section of this bill. There are 21 sections, and several of them do very similar things, so I combine those so that you can see what each one does. Because of the complexity, I think that may be a great idea, even though I usually enjoy being very brief with bill presentations. I think this one demands that we give it a little attention. Section 1 of the bill repeals one of the two provisions central to the Hughes v. State litigation, likely mooting that portion of the challenge. It deletes the offense in 1307A because it's unconstitutional, E and G because they are exceptions to Section A, and the subdivision H1B because courts have found that unconstitutional as well. Sections 2 and 3 repeal the second of the two provisions central to the Hughes litigation, likely mooting that portion of the challenge as well. It also alters related provisions to secure carry permissions in parks and similar places while preserving current provisions allowing law-abiding citizens to carry in federal parks as the federal law provides. Section 4 deletes a reference to an obsolete reporting provision. Section 5 updates references to code sections where we broaden the scope of 1319 and 1320 in sections 9 through 13 of this bill, as we rebuild the offenses for juveniles in order to maintain what we currently have in law. Section 6 removes a redundant section of law that is covered in 3917, 1320. Section 7 removes defenses that are no longer needed due to flipping the language, as I mentioned earlier, in 1307A1. Section 8 is a cleanup because 1307G was deleted in Section 1 of this bill, and it removes the reference and states what current law is today. Sections 9 through 13. Since Section 1 of the bill removes the crime of carrying in 1307A1, we are reestablishing current crimes and defenses for juveniles. Section 14 and 15 maintain current conditions with respect to juveniles being provided a firearm by an adult. We're merging 1303 and 1320, and the intent is to keep consistent with current law provisions. Section 16 clarifies and removes gray areas, even to a point made by a General Subcommittee recently following the Hughes case, Chancery Court decision. It combines hunting defenses and handgun permit defenses along with prohibitions in the current 1321 so that both hunting with a firearm and possessing a firearm where alcohol beverages are served are prohibited if a person is under the influence as defined in 5510-4012. It keeps the permit suspension that's already in the code. Section 17 cleans up a reference to a deleted code item within Section 3 of this bill. Section 18 cleans up a reference already changed in this bill, and I think this is one our legal staff felt like was needed for additional clarification. Section 19 deletes an irrelevant reference to a deleted part in Section 3 of this bill. Section 20 updates references to code sections where we broaden the scope of 1319 and 1320 in Sections 9 through 13 of this bill as we rebuild the offenses for juveniles in order to maintain what we currently have in law. And Section 21 creates a new offense for acting in a threatening manner with a firearm in public. And this is because of the way this is structured, felt like we needed to add that as well. So with that, I'll be glad to take any questions.
You were right on the money for 5 minutes. How about that? All right. We thank you for the explanation. We do have individuals here that wish to testify. So without objection, we're going to go out of session. And the first on our list will be AC Richard Archie. If you will introduce yourself for the record, you'll have 3 minutes for comments and we'll open it for questions.
My name is C. Richard Archie. My name is C. Richard Archie. Is it on? Can you hear me? I don't think I need it anyway. Chairman and committee, thank you for allowing me to come. From our 1796 Constitution, the one that Thomas Jefferson said was the least imperfect that he had seen. Article 10, Section 4, the Declaration of Rights hereto annexed is declared to be a part of the Constitution of this state and shall never be violated on any pretense whatever. And to guard against transgressions of the high powers which we have delegated, we declare that everything in the Bill of Rights contained and every other right not hereby delegated is accepted out of the general powers of government and shall forever remain inviolate. At that time, in 1796, Article 11, Section 26 was the Second Amendment analog. It said that the free men of this state have a right to keep and to bear arms for their common defense. In 1801, the first gun control law was passed, an act to restrain of idle and disorderly persons, be it enacted that if any person or persons shall publicly ride or go armed to the terror of the people, or privately carry any dirk, large knife, pistol, or any other dangerous weapon to the fear and terror of any person, it shall be the duty of any judge or justice on his own view or upon the information of any other person on oath to bind such person or persons to their good behavior. From Andrews v. State, which is our biggest case we've ever had in the Supreme Court of Tennessee with respect to the Second Amendment, after the change in 1870, which gave the power to the legislature to regulate arms with a view to prevent crime, they said this: what then is the protected in the right to keep and thus use? Not everything that may be useful for offense or defense, but what may properly be included or understood under the title of arms, taken in connection with the fact that the citizen is to keep them as a citizen. Such then as are found to make up the usual arms of the citizenry of the country, and the use of which will properly train and render him efficient in his defense of his own liberties as well as that of the state. Under this head, with a knowledge of the habits of our people and of the arms and the use of which a soldier should be trained, we would hold that the rifle of all descriptions, the shotgun, the musket, and repeater are such arms, and that under the Constitution, the right to keep such arms cannot be infringed or forbidden by the legislature. In 2008, the Heller decision quoted Andrews. In Andrews v. State, the Tennessee Supreme Court likewise held that a statute that forbade openly carrying a pistol, publicly or privately, without regard to time or place or circumstances, violated the state's constitutional provision, which the court equated with the Second Amendment. This was so even though the statute did not restrict the carrying of long guns. This bill corrects several inconsistencies in what should be our rights, and I think it should be put on the floor for consideration by the entire House.
Thank you for those comments. Any questions for our guest? Seeing none. Thank you for being with us today. Next on our list, we have Carol Buckley Frazier. You will introduce yourself for the record. You'll have 3 minutes for comments.
Okay. Can you hear me? Yeah. Good morning. My name's Carol Buckley Frazier, and I'm a mother, a grandmother, and a healthcare professional. And today I'm representing the Tennessee chapter of Moms Demand Action for Gun Sense in America. And we definitely oppose House Bill 2064. This is a dangerous rollback of sensible gun safety laws that work to keep Tennesseans safe, which is where we should be putting our emphasis. And that includes domestic violence survivors. This bill would allow convicted stalkers to carry firearms only 5 years after their conviction, where now they are prohibited from carrying at all. It would also create a pathway for convicted domestic violence of domestic abusers to restore their firearm rights in as little as 3 years after the conviction. In our state, the crisis of domestic violence is closely linked to the widespread and growing use of guns by abusers. The majority of women killed by an intimate partner are killed with a gun. In fact, research shows that when an abuser has access to a gun, the victim is 5 times more likely to be killed. Nearly 9 out of 10 attempted murders of women are preceded by at least one incident of stalking. Repealing the exact laws that keep firearms out of the hands of convicted domestic abusers and stalkers turns a blind eye to domestic violence and threatens the lives of survivors. But to be clear, the effect of arming abusers extends far beyond the intimate relationships. This affects entire communities, from children who witness it to family members, coworkers, and the law enforcement officers who respond to it. Tennessee has already witnessed too much gun violence in our communities. We must start prioritizing public safety in this area. In addition to the impact on Tennessee laws protecting domestic violence survivors, HB 2064 would also codify parts of a recent court decision with no guardrails. This includes allowing people to carry long guns, starting at as young as 18 years old, and forcing guns in our public parks, even if they are the site of school sporting events. 2064 floods our communities with guns and rolls back restrictions on who can have them. Common sense laws that keep guns out of the hands of abusive partners can
Ma'am,
reduce.
Your 3 minutes are up. I will say one clarification there. The bill is amended, remove the domestic violence and the stalking provisions that you were speaking about. Representative Powell, questions for our guests?
Thank you. Could you speak, I guess, just a little bit more about some other provisions in the bill that you find concerning? I do know, for example, we've got schools in my community that are literally next to a park. So if you are de facto now having these guns in these parks, then essentially you're having guns right next beside a school building. If you could just speak to that, or maybe just any other issues you see with the bill. Thank you.
Yes, I think that's really important, especially considering that we have had gun violence and death in schools in this city. I don't see, and I think Moms Demand Action for Gun Sense doesn't see any purpose in allowing guns into parks and areas like that. So our whole goal, and we think the legislature's whole goal, should be to reduce gun violence. We are in the top 10 for women killed by men in this state, and the top 10 for the most gun violent state in the country. So we would love to pull those numbers down, and this is just one way to do that.
Any other questions for our guest?
Thank you, Rob.
Seeing none, thank you for being with us today.
Can I have one more thing to say? Would that be okay?
Well, we've got other people that are here to testify.
Okay. Just real quickly. So I'd like to bring up the bill from Representative Lambert with giving a lifetime
That's going to be
order.
that's going to be inappropriate because we're not on that bill today. So if you would like to get with the members of the committee and talk to them individually, that would be fine. So thank you. Next on our list is a Jimmy Music and a Rachel Russell. Are they here? That's no. There's okay. If you will, introduce yourselves. For the record, you'll have 3 minutes each for comments and then open for questions.
Good morning. My name is Rachel Russell. I am the Deputy Counsel of Operations for the Tennessee Bureau of Investigation. I do want to start this morning before getting into some of our opposition with the current language by letting the committee know that we have been working with Chairman Todd. He has been, we've had meaningful, law enforcement community in general has had meaningful conversations with Chairman Todd. We are appreciative of the changes that have been made in the amendment that's currently in front of the committee. We are hopeful that those conversations will continue. However, based on the way that the bill is currently drafted, we do still have, the Bureau does still have concerns as it relates to public safety, and that is why I am here today. So really quickly, I want try to get this in that 3-minute time span. The committee is aware of the Bureau's position concerning the open carry of loaded long guns and our belief that it creates a dangerous situation for the communities across our state. That is not just for the individuals who are carrying those firearms, also those individuals that encounter those people, and additionally law enforcement officers who have to respond in those situations. We believe that that is exacerbated based on how those firearms are carried, the manner in which they are carried, as well as the places in which they are carried. So in that same vein, in that same regard, we do have concerns with opening up the carry in parks, moving it from the way that it currently stands with enhanced firearm or enhanced handgun holders to the open carry to anyone that is not prohibited. Aside from the open carry piece of this bill, there are some other concerns that we have with changes that are being made in the current law. Specifically, the defenses that are currently laid out in 3917, 1308 are in the law in response to the language that is being removed in A and 1307. It is our reading of the bill as written that if those defenses are left in, that those defenses will now only apply to those individuals that are otherwise prohibited from possessing in Tennessee. We have concerns with 1308 being left in the code if this bill is to move forward based on that. In addition, there is the removal of those individuals with certain DUI offenses from 1307. Again, this is a piece that we think can be worked on, that instead of removing it entirely, there can be some change in language that mirrors the addicted to alcohol that currently exists in our purchasing statute. So we do believe that there are some changes that can be made there to make that work. And then also related in that vein of alcohol and intoxication, the way that that has changed in this bill from the way that it's currently written, moving away from that kind of bright line rule, we believe that this new standard complicates matters for law enforcement. I will defer to Mr. Music to explore that further for the locals.
Good morning, Chairman and Committee. Jimmy Music, representing the Tennessee Sheriff's Association, Tennessee Association of Chiefs of Police. Will echo what Ms. Russell said. Obviously, this is no small undertaking. Chairman Todd has a lot of shoe leather into this, and we've had a lot of conversations and trying to make this accomplish his intent and remove as many concerns that the law enforcement community has. And that's very much appreciated for us. I want to reiterate too that our perspective on this is public safety, and we're coming from a place of the job that our folks sign up for, with the understanding also that that is but one perspective that you all have to consider, and we understand that. I don't want to rehash everything that Rachel had mentioned, but we agree with the 1308 defenses that you're left with, based on our understanding that potential bad actors could utilize those now that 1307 has been changed. The other thing, very appreciative of the brandishing kind of language that was added into the latest amendment. That's very important to us from just a logistical, how officer or deputy on the street, how they have to do this job is we don't always operate in gray area. We don't operate well in gray area. We need very good clarity to know when to engage and when not. And we want to make sure that we're not violating any other's rights, but we're also keeping our officers and deputies safe. And so the brandishing does help that. I know that one suggestion that we made has been that, considering certain public assemblies, protests, that kind of thing, where you could have a large number of people, maybe in opposite sides of an issue. And so, it gets very gray for us on, for those was someone carrying that firearm in an alarming manner, tempers are up. There's a lot of hostility there. And so, the preference would be from our folks is that there was a bright line there that in certain types of assemblies, especially on public property, that it would not be allowed. I'll stop there and be glad to answer any questions that the committee may have, Mr. Chairman.
Thank you for that. Questions for the guest, Representative Salinas.
Yeah, this is a really big bill, and I do appreciate Representative Todd going through it kind of section by section and describing that. I think my first question is, what was your name, ma'am?
Rachel Russell.
Ms. Russell, you were describing kind of the concerns with 1307 and 1308. Can you expound on like the burden that would cause, that those sections and applying those sections would cause the department? Is it?
So it is our understanding that at the time that those defenses were written into 1308, they were defenses to what is the Section A, the carrying with intent to go armed language. Those are defenses to that A. In this bill, it removes A entirely. By removing A, that now means that those defenses that live in 1308 are going to apply to those individuals that are still left in 1307 as being prohibited from possessing. So your convicted felons, your misdemeanor crimes of domestic violence, things of that nature, that those defenses, if left in code, will apply to those individuals.
Okay, thank you. And then my other questions for Mr. Music. You kind of touched upon this, but in terms of safety and the safety of the officer specifically, can you explain more that aspect of this bill and how what that looks like?
Sure. So for, there isn't a way to conceal carry a long gun. And so the alarm that may occur in the public space, we will get those calls for service. And so what I'm getting at is when you have that call for service and you're trying to engage, you can have a consensual stop. That means, you have a right, if I want to talk to you as an officer, to say, go pound sand. I don't want to talk to you. After that, to get a Terry stop, you need reasonable suspicion that some crime has been committed or is being committed. And so you don't have that with a blanket that it's allowed unless you can prove that it's not. So without some kind of independent, reasonable suspicion that you can articulate, if they say they don't want to, that's okay. Puts the officer in an awkward position of, okay, now what do we do? And if they're not breaking any law or anything like that, most likely it's not. But there will still be those, whether it's the people at the park or the people on the side of the road or wherever the individual is, that are going to have concerns. And there's an expectation that I think law enforcement is going to engage further, and they may not be able to, both legally and constitutionally. And so, on the officer safety side of that equation is you don't want things to escalate at that point where you have a difference of opinion or anything like that. And you've got officers and deputies who are not carrying a rifle at that point.
Okay. If this were to pass, would there need to be training for all sheriff's officers, retraining on how to engage it and still apply the law?
Thank you for the question. So, every year we get continuing training on all the laws that you passed, and we obviously would do the same for this one. On the original side, the same thing happens at the academies. That they would change their curriculum to align with the current state of the law.
Leader Lambert.
Thank you. I was monitoring while I was out of the room, and I deeply appreciate both y'all's testimony. And this is a very important bill that both preserves civil rights and liberties and safety as well. But I have to introduce somebody real quick and go ahead. And I apologize, Mr. Chairman. My baby girl, Allison Lambert, is here visiting today. So y'all make her feel welcome. Thank you. Sorry, Mr. Chairman, I can't help myself. When we began this journey a long time ago, she was just a baby, and she's been there for every parade and door knocking and everything else. So she deserves recognition. Thank you, Mr. Chairman.
Any other questions for our guests? Representative Powell.
Thank you. So I guess overall, in your estimation, the bill is currently amended. If this was to pass and become law, this would create more safety concerns because of firearms and also to both the public and to law enforcement. Would you say that's a fair question?
We're not a magic 8 ball. I'm not Nostradamus. I get nervous about making predictions. There are a lot of other states that have similar things. I think the one fair thing is that it may fundamentally change how things look in Tennessee, and that may be okay. And it may change to some extent how policing is conducted in general.
I have one other question. So you stated that it's tough to conceal a long gun. Under this, would it allow for people to more easily conceal long guns, and would it prevent law enforcement from, if they suspected that somebody had an armed gun that was concealed, from approaching or disturbing them?
I'm trying to think on the fly here. So I'm assuming like a trench coat or something like that could conceal a long barrel rifle. As it is right now, you can approach that individual if you see that because you can't have the firearm loaded. So you can't have a magazine with rounds in it or a round in the chamber. And so when we're talking about that Terry stop, that if you were gonna initiate that encounter, you'd be verifying that the rifle and the person is following the law and that it is not loaded. So you wouldn't have that anymore, that ability.
Okay. Yep. And if I could, I was just thinking of specifically the terrible murder of Charlie Kirk, and how the person that committed that act actually, possessed a long gun and was being concealed. And I can't speak to whether or not that was armed or unarmed, and they might have had time to arm that. But I just think that's problematic, that makes that situation, preventing that murder, even more difficult. So thank you.
Any other questions for our guests while we're out of session? Seeing none, we're going to go back into session. Chairman Todd, you're recognized.
Thank you, Mr. Chairman, and I appreciate you clarifying from the previous testimony that this does not include anything about stalking, restoration, or domestic. That has been drafted out of the bill in the draft that's before you. And it's been mentioned that our obligation is to keep people safe. And unfortunately, that is not what the Constitution says. That's not the oath of office each of us took. It is to protect people's liberties, their freedoms and their liberties, especially their civil rights. And that's what this centers around, is a civil right that has been infringed upon, not my opinion, the court's opinion, over and over and over again. And we're going to continue to get sued, and we're going to continue to lose in those cases if we don't fix it. And this is our opportunity to fix that. It's also been mentioned that this may make some law enforcement uncomfortable, and that is not my intention at all. Law enforcement takes the same oath of office that each one of us does. And I had a sheriff call me that was involved in the discussions about this bill previously and said, we didn't sign up for this job to be easy. We know there are difficulties in interpreting the law and enforcing the law, but we will do that. Our first obligation is to uphold and enforce the Constitution and protects people's rights. So I just bring that to you. That is my whole intention in this bill, not to make anybody uncomfortable. The issue about long guns and carrying in public, right now, over 40 states allow this. Over 40 states. And I don't think I saw anything on the news this morning about that being a problem. I didn't see anything last week, and I didn't see anything last year. It doesn't happen. Folks use common sense. Right now, somebody mentioned carrying in front of a school. You can carry a gun in front of a school, a long gun. It just can't be loaded. And you scare people to death doing that. People don't do that. It's stupid to do that. So there's some common sense out there. There are provisions in here to take care of the bad actors. We have other areas in law that take care of those bad actors. Everything's been mentioned today. So with that, I appreciate your indulgence.
Thank you, Representative Powell.
Thank you. And the sponsor knows we disagree fundamentally on this, but I just want to say, to me, life in the Constitution comes before liberty. And I think, unfortunately, this situation is going to cost more Tennesseans their life. It's going to put more people in danger, especially law enforcement. And while your intent might not be to harm law enforcement, we heard directly from law enforcement that they believe this is a bad bill. So again, we disagree fundamentally on that. You know that. And so I just wanted to say that. But thank you.
Representative Scarborough.
Thank you, Chairman. And Chairman Todd, thank you for bringing this legislation. And again, what I'm encouraged about is the conversation between yourself and the advocates of the law enforcement community. I think it's pretty obvious that they're not trying to infringe upon the Second Amendment rights. I think they're trying to work with you. And it's for that reason that I'll support the bill moving out of committee.
Chairman Farmer.
Question on the bill.
Question's been called. Any objection? Seeing none, we're now voting to send House Bill 2064 as amended to full judiciary. Has everyone voted? Does anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 7 ayes and 2 noes.
The ayes prevail. House Bill 2064 is amended, moves on to full judiciary.
Thank you, Chairman and Committee.
Members and those that are here, our guests, we apologize. Our time is up for today. I know many of you have traveled a distance to testify. I hope that it wasn't too big of an inconvenience, but we hope that you'll be able to be back with us again next week. All remaining bills that were not heard today will be rolled to next week's calendar. We are adjourned.